9 Ontario First Nations have filed a legal challenge against Ontario's Bill 5 and the federal government's Bill C5, which are both designed to allow those governments to fast-track major infrastructure projects, but the First Nations fear this will be used to trample their inherent treaty rights. Among the complainants are 3 communities from our region, Arrowland, KI, and Ganookaming First Nation, which is led by Chief Sherry Taylor.
I am here for the future of our children.
The legal filing is a constitutional challenge, not an injunction, aimed at striking down Ontario's Bill 5 and Sections 6 and 22 of the federal Bill C5. The application does reserve the right to file an injunction if the government's approved developments under the new laws before the courts weigh in. The First Nations stress that this isn't about opposing economic development, but about ensuring it happens with constitutional and environmental safeguards in place. Taylor says both levels of government are using threats from the U.S. as an excuse to circumvent the protections.
Crown governments are showing they are more concerned with the threats of our neighboring president than the threats that First Nations have been facing for centuries. Canada and Ontario must start showing that they need to provide proper infrastructure and economic participation requirements to First Nations. These are the partnerships and initiatives that will protect the economy.
Both laws, the Building Canada Act and Bill 5, give their respective cabinets and ministers unfettered, unlimited authority to wave a magic wand in any instance when approving a project or what could be a vast area of land or zone for multiple projects, to say that a bunch of other laws are not going to apply.
Both governments have responded to the challenge. Canada insists that Bill C5 ensures consultation and supports Indigenous equity in major projects, while the province says it's having, quote, productive conversations with First Nations who share its vision.